Is 32 hours considered full-time in Colorado? Many Colorado employers provide employee benefits, pay differentials, job assignments and other important benefits on the basis of whether an employee works full-time or part-time. This can lead to a lot of questions about what is full-time under Colorado employment law. These questions typically do not exist when employees work a 40-hour workweek but usually arise when employees work 32 hours or some other slightly lower number. For example, you might wonder, is 32 hours considered full-time in Colorado? The answer depends upon to what issue the full-time status relates. Basic rule for full-time status in Colorado. Colorado labor and employment law does not contain an expansive definition of full-time or part-time status for employees. In general, an employee is full-time or part-time based upon an employer's own definition. Full-time versus part-time is often a dividing line for benefits or certain positions, but that line is typically not drawn out of a federal or Colorado employment law. However, several employment law statutes set minimum or maximum limits for how much an employee may or must work to obtain a specific status under the law. When a labor law or employment law does not set a minimum or maximum hourly requirement, it is generally up to the employer or an agreement between employees and employer to determine when full-time status kicks in for particular benefits, job assignments, compensation and so forth. Many Colorado employers consider full-time a 40-hour workweek schedule, but some draw the line at a smaller number. The best way to assess whether you are a full-time employee in Colorado at 32 hours is to focus on the specific subject in which the full-time status applies. Applying a single rule to every workplace issue might result in misinforming yourself. Operating on misinformed positions could put your job at risk. As always, if legal issues are involved in your question, you should consult employment lawyers in Colorado as soon as possible. Overtime pay in Colorado. Overtime pay is not exactly a full-time versus part-time issue, but it definitely deals with the work hours for an employee. Federal and Colorado overtime laws calculate overtime pay for all hours in the workweek exceeding 40 hours of work for all non-exempt employees. For this purpose, an employee can be considered a full-time employee at 40 hours under the statute. An employee working overtime hours is more than full-time. An employer could begin paying overtime pay at 32 hours if it wishes, but that is an extremely uncommon practice. Employee benefits and full-time status. Most employees care about full-time status because employers make benefit plans available to full-time employees but may not extend them to part-time employees. When we think about employee benefits from an employment law perspective, we can think of them in two categories. The differences in categories is important to how and when an employer may make benefits available to employees based on work hours. Regulated benefit plans under federal and Colorado employment law. First are employee benefit plans regulated by law. Cafeteria plans, $#, for example $#. Employees of federal and Colorado government agencies often offer similar benefits operated under a plan regulated by state or federal laws as applicable. Although the complex regulatory apparatus behind ERISA does not apply to these plans, they still generally follow similar regulatory mechanisms. Benefits regulated by ERISA or other laws must operate as a plan with established rules. The applicable laws often set requirements or eligibility to the plan. Often employers may establish rules for eligibility based upon hours or length of service with the employer within the permitted confines of the law. Often employers can set eligibility on completion of a certain number of work hours in a year, which effectively makes many part-time employees ineligible for benefits. A specific weekly hour threshold exists in the Affordable Care Act. Under the ACA, employers must make available compliant health insurance to all employees who regularly work at least 30 hours in a work week. For the purposes of the ACA, an employee is full-time if the employee works 30 hours in a regular work week. Employers cannot set a higher limit for full-time like 32 hours or 40 hours. Other benefits or fringe benefits. Employers may offer other benefits not regulated by ERISA or other laws. For these benefits, an employer can generally set whatever constraints on eligibility it wishes. Employers can set limits for work hours, length of service, job title and so forth to make these benefits available. If an employer sets a threshold for work hours as a full-time employee for these benefits, it may do so and even set different standards for each benefit. Unemployment benefits in Colorado, and employment status. Colorado unemployment benefits require that employees work for a given length of time and earn a minimum of $2,500 during that period. It does not require an employee to work any specific number of hours in a work week or for an employer to designate employees as full-time employees. So long as an employee meets the length of service and wage minimums, then the employee qualifies for a claim. Some employers, as a matter of course, pay severance benefits to employees designated as full-time employees. Here the issue may be complicated because a severance plan may fall under ERISA regulation but does not necessarily fall under ERISA regulation. The best way to begin answering that question is to review the severance information available from your employer, which may include ERISA language.